So,
We have a quorum, Brandon, so we can actually vote on the minutes if you want to.
yep.
Okay, well, let me call the meeting to order, then the meeting of the Policy and Governance Committee. Shall we take a roll call? We have Councilman Gaddis is here. Tina Beeman, I see. Yeah. Georgette Cicero. Douglas Clemens. Christina Diamond. Mari Collazo Cruz, and Director McGee. So with that, we will have, I'll take a motion to approve the minutes from our last meeting.
So moved.
May I get a second?
Second.
Second. All right, thank you. All those in favor indicate by saying aye. Aye.
Aye.
And the minutes are approved. All right. Director McGee, what is on the agenda?
The only item on the agenda, well, two. One to approve, which we did, and then we'll provide you with some updates.
Okay. Shall we have the updates then?
Yes, sir. Good morning, everyone, and thank you all for joining the SEC's Policy and Governance Committee. As we close out the year, I want to be extremely clear about today's meeting and respectful of everybody's time. The items before the Policy and Governance Committee today are for update and discussion only. No votes are required. Over the past several months, staff has been working through a series of policy, regulatory, and governance matters that fall squarely within this committee's purview. Today's agenda is intended to ensure the committee is informed, aligned, and has the opportunity to raise any questions or provide guidance as needed. These updates touch on areas central to the integrity of the social equity program, particularly ownership, control, and our evolving regulatory and enforcement responsibilities. So as always, our focus, y'all know what I'll say, remains on fidelity to the statute, consistency in our application, and protecting the purpose of our social equity framework. So I'm done. Staff will walk us through each of the items in detail. And again, I want to thank this committee. I want to thank my staff for the careful and methodical work they've been doing to advance these issues, especially as we approach the year end. Team, on you.
Thank you. In regards to the change in ownership during our last meeting, we discussed the current prohibition on adding backers to a cannabis license application prior to final licensure. We know that this creates challenges for all applicants, but in particular for our SEIs if they find themselves in a situation where their backer leaves the state for whatever reason or otherwise transitions out of business. So as part of our legislative priorities, we submitted language creating an exception for social equity individuals to be able to add backers prior to final licensure. There are minor language adjustments that we're working through, but all stakeholders involved seem to be in favor of this change. Another change, ownership and control matter that we've recently identified is a possible loophole where backers composed of entities instead of individuals are able to bypass that prohibition by selling their business to other entities. So we've seen, for example, entity A is part of the application, but prior to final licensure, they get bought out by company B, and they continue doing business as company A, but it's really company B that's behind the backer. So we're looking into that. Obviously, it's a loophole that creates a disadvantage if it's not equal for everyone. So when you have these big backers having the ability to sort of swap in and out, and individuals are not able to do that, it creates equity issues. So that's something that we're looking into.
Okay, may I interrupt just for a minute?
Sure.
Could you describe, sounds like there has been a situation, a specific situation that you've had to address. Could you describe what that was, please?
Sure. So, I mean, I don't want to identify the entity
Okay,
on the call,
right.
but it's basically we were during our meetings with multi-state operators, we met with their representatives and one of the MSO's representatives, and we tried to understand why the applications had different names throughout the process. And
Mhm.
based on what we were able to find online, it was still unclear. So there were 3 entities associated with it. There's Company A that was at one point bought out by Company B that was unable to meet its financial situation, responsibilities, and it was then taken over by a financial institution. And the financial institution now owns something like 25%. And then there's 2 individuals that own 12.5%, and the SEI is 50%. Well, Company C, which is the financial institution, has never had any interactions with the SEI, and they've been in the
Mhm.
scene for almost 2 years now. So we're trying to understand, how are you a backer partner to a social equity individual that you've never had any interactions with? And the changes were all reported through DCB, but we never received notice. And while the ownership of the social equity individual was never affected, there were still transactions that we feel we should have been privy to.
Mhm. Clearly.
I don't know if that was clear.
Got it. Okay, thank you. I appreciate that. I won't interrupt again, but
Oh,
please
no, you
continue.
can interrupt anytime. You're the chair. And the last point regarding ownership matters, we did issue a notice of intent regarding the regulations for change in ownership and control. And as we've discussed in the past, these are a replica of the policy and procedures that we've had in place since 2022. So there's really no change or impact to how we will continue to conduct business. We're statutorily required to have a regulation around this matter, and due to different personal transitions and other
Mhm.
challenges, it was not issued as a regulation. So we've done that. We did that at some point in mid-October. We're now in the comment period where folks can submit written comment to us for our consideration. That period ends on December 31st, and then we move on to the next phase in accordance with the state's regulation process. That is it on backers and ownership. I don't know if there's any questions on that before we move on to the next item.
One other question. So some internal changes in ownership took place. We weren't notified of them. And when we saw them, we would, it was unclear what happened. Could that be remedied with by saying anytime there is a change of any type of ownership, we have to be notified? Because it seems to me that they, with the changes they made, their attorneys must have looked at that and blessed it and said, well, there's no ruling, there's no regulation against this, so let's go forward. I'm just wondering, it seems to me that we might remedy that and other changes by saying anytime there's a change, internal or otherwise, we have to be notified.
Yeah, I think that's the direction we're going. We had initial conversations with DCP, and they agreed to look into how these changes have taken place despite the statutory prohibition that they take place. So again, it appears to be a loophole, so we might need stronger language around it, or as you said, adding some sort of amendment to the statute requiring notification of SEI entities to notify any change, not just changes that affect SEI ownership.
Right. Okay, thank you.
I'll move on to the next item, which
Okay.
is investigatory powers. So as an entity, among other items, right, we're tasked with issuing the criteria for social equity licensees, including ownership and control requirements for those seeking licensure under the social equity program. The council in 2024, prior to this administration, issued guidance around social equity eligibility and ownership and control, both for social equity lottery applicants as well as equity joint ventures. The guidance establishes how we review those applications in accordance with statutory requirements. And as you know, the review is limited to what is presented at the time of the application and the request to be a social equity individual. And it's also limited to how they propose to conduct business at that time, right? So they might have a vision on how they will be conducting business for the foreseeable future, but we don't see what actually happens when they're operating. So RORACA enables the council to conduct hearings, conduct investigations, and a series of other powers related to how we effectuate the purposes of the statute, which is to ensure that social equity individuals maintain ownership and control for the prescribed period of time. So for social equity lottery applicants is 3 years, and for EJVs it's 7 years. So there's a rising concern around compliance with ownership and control. So we intend to move forward with enforcing the applicable statutory provisions where we can basically prevent SEIs from being used as figureheads in these entities, and not just someone who checks a series of boxes and becomes eligible to
Right.
apply or request social equity status. For example, we've heard of situations where it's unclear whether the SEI, or it's not really unclear, it's evident that the SEI does not have control over daily operations as required by SEC guidance. There are others who are not able to access basic accounting information regarding the entity and how business is being conducted, how much money the entity is making. So to that end, we'll be moving towards drafting a policy and procedure that will then be put forth as a regulation to guide how the investigation process is conducted by our team, and to ensure due process, right? These folks, by way of having a license, have a property interest that is protected and needs to undergo a due process procedure, if you would, to take any action against it, whether it's denying withdrawal, not allowing the business to continue, a fine, right? So there's a series of actions that DCP can take based on our investigation and a report that we then submit to DCP for action against the license. We've already spoken to DCP about it. They are on board, so we're finalizing details. And again, we want to make sure we have a process that is uniform for everyone. We don't want claims of subjectivity or arbitrarily
Bias.
applying one thing
Yeah.
to one and not to the other. And that's where we stand in regarding ownership and control investigations.
Yeah, with the
I'm not sure if there's
excuse
any
me,
questions around that.
with the talk of the feds relaxing their right now it's just a rumor, but thinking about relaxing their regulations, we're likely to see more activity from backers in terms of strong arming social equity applicants.
Yes, that's definitely one concern. And it will allow other players to like, big pharma and others to enter, the play. So it is concerning. Uh,
Definitely.
we're trying to stay on top of it.
Wait. How
Awesome.
Is there,
Sorry.
go ahead.
I do have how many situations have you seen that that would fit in this category?
I'd say from the top of my head, 4 different, instances.
That's
One
enough.
that eventually closed, but I'll say this. I think that my person, and I've also not attended some of the roundtables where I think others have spoken up about this, which is what actually triggered us meeting with MSOs. I think that a lot of folks are not speaking up. One, because they have non-disparagement agreements with their backers, and they might fear that coming forward will increase the strain, or will worsen rather, the strained relationship that they may already have with folks. I have one
Mhm.
SEI who's in the process of requesting approval for their EJB, and we met and explained to the individual certain provisions within the proposed documentation. And she said, she's clearly not aware of some of the implications. And then she was she was unclear on how to move forward because she didn't want to strain their relationship, right? She was hesitant because she had heard the experience that other individuals are having, and basically was very grateful that we were pointing some of the things out. But at the same time, there was a fear of if I speak up at this point and I say, hey, this is not what I thought it was, how is that going to affect me? So I think when I say 4, I'm not saying that those are the only cases that are out there. I'm certain that there are more. Very
Okay.
fear coming forward because of what it may mean in terms of their relationship. And that's what I'll say.
And I'll just add, Chairman, and committee members, this has also prompted and informed how we engage with our social equity individuals. We're actually deepening our relationships, trust, quite frankly. We've been meeting with them individually to assess and to also provide a cursory look at some of the documents while we are not their legal representation. This is, in fact, why the Social Equity Council exists, right? To provide resource, guidance, FYIs, and you make the best decision that you can possibly make as a business person. So we've learned a lot, I will tell you that. And we've also, for the record, have met with all of the legacy multi-state operators to just meet and have conversations and to better understand what we don't know and how can we inform social equity individuals as they continue to stand up their business.
Do you feel, Director McGee, that you have sufficient resources to address this issue? I mean, because it sounds like when at least the times that I've been involved, and from the beginning, I don't remember ever having a discussion of how we would address conflicts between backers and their and social equity applicants, because that can be messy and take a lot of man hours. So I'm just asking, are we sufficiently equipped to do that?
Yes, we are. And your question is a bit nuanced, and I'll do my best to respond in a way that everyone on this call and those who are watching understand where we sit. We want to establish good relationships with all of our stakeholders. We know that these folks are business persons, and we want to respect the boundaries there. And we want to support as best we can, where appropriate, these social equity individuals. We will also, in terms of staff resource, we will have another staff attorney who will be joining our team. And I'll talk a little bit about this. Shameless plug for those who are watching. We will have our finance committee. We have our chairperson here, and we're going to talk a little bit about where we're going. But our hiring has been extremely intentional. While our strategic plan is just that, we've had to adjust, amend, and move accordingly to support our operations, quite frankly. But to your question, we could always use more money and more people. But as of now, I think our mighty staff of 2 attorneys with 1 onboarding shortly, I think we're sufficient for now. Oh, and by the way, here's another update. Douglas and Madi will be working on establishing a partnership with some of our law schools to provide clinics and give that real-time experience to those professionals who are pursuing their Juris Doctorate. So did I say that right? Or is it just a law degree? I don't know. I don't want to mess up. Okay, got it. Mr. Shirley, back to you.
All right. Thank you for that. And it was I meant that literally. I wasn't trying to suggest that you did not have enough, but I really just wanted to know,
That's a great question. Yeah.
If you felt that you were, good.
Yeah, and I mean, yeah, I'll leave it at that.
All right. Thank you. That's very helpful. At this point, so we will have to, it sounds like there's something that this committee will have to, at some point, will bring to the full council for a vote. Is that, what do you envision as a process?
Yeah, at this point, we're still what we refer to as going through the sausage making process of, just shoring up where we are as SEC, making sure our board or our council are fully aware. And then as we start the legislative session, which will start at the top of the year, and it's a short session, we just want to make sure all players are aware. And when it's time to make those final decisions, again, we're all on the same page. So at this point, there are no votes required at this point. And should there be a vote required, we can plan an emergency meeting. But I think we're in a good place as of today.
All right. Thank you. All right.
Go ahead.
Oh, other issues?
Well, there's one other item that we can discuss because time allows us to. And it wasn't on our list, but it is the changes at the federal level around hemp. And Douglas, I'll let Douglas touch on that, and then we can discuss the implications on the FBIs and the industry at large.
Hello all, thank you for the opportunity to speak. So when the President signed the bill to reopen the government back in November, attached to that bill were regulations, or should I say loopholes closed, and regulations regarding hemp specifically. What this essentially entails is that a majority of hemp products will lose classification as hemp and move over to cannabis. Anything that is synthesized with certain cannabinoids or chemicals will now be considered cannabis. The biggest, stakeholder in this would be our liquor license holders that sell infused beverages. Those infused beverages will now be considered cannabis and illegal federally as well as at the state level. This puts Connecticut in a very interesting situation because we do have hemp farmers in the state. We're working with the Department of Agriculture as well as DCP and other state agencies to kind of figure out what this is looking like for the state, specifically for our hemp farmers. There has been some mention of a pathway to cannabis for the hemp farmers, which is something that we are against, just to be blunt about it. We have numerous stakeholders that have gone through this process and are still going through this process to be able to, cultivate and dispense cannabis in the state. And if that pathway were something that was actually created, it would definitely ruffle some feathers and put all of our people who are in waiting or have to go through the process into a very precarious situation. I'll let Madi expand on that.
Thank you, Douglas. So, I mean, there isn't much more to add outside of, these folks have an operation it's already up and running. Whereas we have at social equity individuals and general general lottery individuals that are still trying to get up and running, right? They went through a certain process, they paid certain fees, or are raising capital to pay those fees, to find a location, to build the infrastructure required by DCP, and so on and so forth. And the hemp farmers, most of them already have all these, right? They have a location, they have their greenhouses, they have everything to hit the ground running. So, it places folks that are currently in the cannabis industry and have done it the way that RRACA prescribed, at a great disadvantage. So the concept of providing relief to hemp farmers is directly in conflict with allowing these folks, these social equity individuals in particular, to enter the cannabis industry. And obviously there's other implications as we continue to move forward, but primarily the cultivators that have had great challenges finding a location because they were first constrained to a DIA. And, I think we're all familiar with the changes that had to be made to RRACA to try to allow the cultivators to build out and start their business, and having, there's 65 hemp farmers out there. Around 8 of them have the endorsement or license to go to do consumables, but nonetheless, 65 hemp farmers is a lot of hemp farmers if they're all going to be cannabis cultivators. And we have 12 licenses that I believe are in provisional status, and then there's 12 others that haven't paid the $3 million or transitioned to micro cultivator. But we know the challenges that they faced, right? So this additional competition, this is going to crush them, quite frankly.
And just to add, I don't know, maybe I missed it. We're also being intentional about creating some guardrails, around social equity individuals. And I think both Douglas and Madi alluded to it, but I just want to underscore, we're not a hard stop, but that is our stance. We also know that we have to come to the table with solutions, of which, we've met with all of our stakeholders, in particular, General Law, Office of the Governor, and others. So more to come on that front.
So it seems to me that that's a double-edged sword. I'm not going to spend a lot of time on this, but they are allowed to be, they're going to be treated as cannabis producers. Is that am I wrong about that?
I think that's an option that may be on the table, right? We haven't, well, the government, right, the legislature ultimately hasn't finalized, but one of the options would be to allow them to on-ramp somehow into the cannabis industry. So when I say provide relief, it's the legislature trying to figure out, what do we do with these hemp farmers that have an operation and all of a sudden their operation becomes illegal? So one of the relief options is to allow them to on-ramp. There are other options, right? Well, just prohibit it entirely, like the federal government did. I'm not sure that's the route that they're going to go. And then there are some sort of in-between alternatives where they're allowed to produce low potency products, or other alternatives where they're not fully into the cannabis industry with the limits that the cannabis industry currently has. So
Yeah.
they won't automatically be considered cannabis, or I'll say legitimate cannabis enterprises, right? They will be considered cannabis. It's where their legitimacy will come into play, I guess. Is what I'm
Okay, yeah, because I'm wondering then, for those of them who have banking relationships with, federally insured deposit institutions, right now, cannabis companies are not allowed to have that. So, and will they have to give that up? Will they be grandfathered? I'm just, because if that, what's good for the goose is good for the gander. I mean, if they're allowed to have federal relationships, banking relationships, then our cannabis folks should be allowed to do that as well. But I know that's off the point.
Yeah.
No, no, it's all a part of the conversation. And what you're saying exactly underscores our investigation discovery mode that we're in, but also being ahead and actively, engaging in the conversation around, our concerns, but also here are our solutions and advocacy baked into that. I also know some of this is a bit not out of our scope, but it's like congressional. And so I'm going to have to tap into, meeting with all of the legislative bodies just to provide awareness and education around who we are, who we stand for in the communities most impacted by this, right? And so that's where we are at the moment. And so we'll be on our educational awareness tour, if you would, at the top of the year in 2 weeks, letting folks know this is where we are, and look forward to engaging a bit more deeply on this.
Thank you. Thank you for that.
In response to your concern around banks, Mr. Shirley, we did hear during one of our large group meetings that one of the hemp farmers, that their financial institution did call their line of credit out of fear that when this becomes illegal next year, they would not be able to meet their financial commitments. So I think banks are already moving in that direction because of the federal change. But then we also have the potential rescheduling of marijuana or cannabis,
Right.
where if that happens, there might be a door or a way in where banks might be able to, or might be willing, right, to provide banking to the cannabis industry. So it's kind of, I think it's a waiting game at this point to see what actually happens with the rescheduling.
Okay. Thank you. All right. So at this point, are there action items for this committee?
No, sir.
All right.
Well, ... Continue to ask questions, continue to think through, given what you know, if you have any solutions, feel free to forward that over. We'll be sure to keep you all abreast as to the meetings that we're having, updates that we're getting. So your homework would be just to be on the lookout for these emails.
Yeah, and in the near
Thank
future,
you.
the policies and procedures that we'll be providing you for purposes of the investigations, right? We usually put those forward for the meeting to review and approve before we submit them to the council. We very much appreciate your feedback and expertise. So we will be submitting those to you. And then I think that would be a next action item.
All right. Thank you. Are there any questions from committee members?
Mr. Chairman, seeing no further questions, I move for adjournment.
Second.
All right. You've heard a motion for adjournment. May I, well, we don't need a second, I don't think. All those in favor indicate by saying aye.
Aye.
Aye. All right, meeting is adjourned.
Happy holidays.
All right, happy holidays to
you.
everyone. Thank you.
Same
All
to
right.
you.
Take care.
Take care.
All right,
Bye.
take care.